Thank you very much, Mr. Chairman and distinguished members of the committee, for this opportunity to present my views on HB number 4994, instituting the Bangsamoro Basic Law. The bill is being filed, I understand, pursuant to the comprehensive agreement of the Bangsamoro signed on March 25, 2014 between the government of the Philippines and the counterpart, the Moro Islamic Liberation Front. It is the second attempt to solve the armed conflict that for so long has dominated the relationship of the government with Muslim Mindanao. The first one, the Memorandum of Agreement on Ancestral Domain, or MOA-AD, which was made in 2008, was declared void by the Supreme Court for being beyond the power of the government to make under the Constitution. Comparing the two agreements, I find that much has been done to bring the proposed Bangsamoro Basic Law into conformity with the Constitution. And for this, I think, Mr. Chairman and members of the committee, acknowledgement should be made of the work of those who have done this, in particular, the two peace panels and the legal experts. I regret, however, that despite the splendid progress made toward a peaceful solution of the Mindanao conflict, I still entertain doubts concerning the constitutionality of certain concepts and provisions embodied in HB number 4994, and I should like to discuss them very briefly. First, the Bangsamoro territory. The reference in the bill to the autonomous region as a territory and not as a autonomous region, and as the ancestral homeland. I was saying the reference in the bill to the autonomous region as a territory and as the ancestral homeland of the Bangsamoro people is contrary to the Constitution, which considers the autonomous region provided therein to be a part of the Philippine archipelago. The term territory is defined as a part of a country separated from the rest and under the jurisdiction of another country. Such, for example, was the Philippines as an unincorporated territory of the United States, part of the United States and yet separated from it, before it was granted independence on July 4, 1946. Hence, to call the autonomous region in Muslim Mindanao the Bangsamoro territory is to consider it as a separate part of the Philippines, although under its jurisdiction. The recognition of the right of the people to self-determination, to chart their political future, reinforces this notion that Bangsamoro is a separate political entity, although under the jurisdiction of the Philippines. Such a political entity is only a little different from the associative state called Bangsamoro juridical entity in the MOA-AD, the court declared unconstitutional in 2000. The dismemberment of the national territory can only result from a provision, this provision in this bill. What the court said in that case applies, I believe, to the bill in question. The court said the Constitution does not contemplate any state in the jurisdiction of the Philippine state, much less does it provide for a transition status that aims to prepare any part of the Philippine territory for independence. Second, the Bangsamoro people. I've discussed territory. I'm discussing actually the elements of what we call a state. Second, the Bangsamoro people. By providing who are considered Bangsamoro, the bill in effect gives the Bangsamoro Parliament the power to enact an electoral code limiting suffrage and membership in the Bangsamoro government to Bangsamoro people, thus denying the rights and privileges of national citizenship guaranteed in the Constitution. Non-Bangsamoro, although Filipino citizens and residents of the region for the requisite period, for example, can be disqualified from election to the Bangsamoro Parliament and appointment to the Cabinet. This is because the definition in the bill of who are Bangsamoro performs the same function that the definition of who are citizens of a nation or a state does in a national constitution. Third, the form of the government. The form of government of the Bangsamoro government in particular. The bill provides for a parliamentary form of government in which powers of government are vested in the parliament. The chief minister, who is head of the cabinet, is elected by the majority of the vote of the parliament from among its members, while the deputy minister and a majority of the cabinet are appointed by the chief minister from the members of parliament. The cabinet performs executive functions. This provision of the bill is contrary to the constitutional provision that the government of the autonomous regions shall consist of the executive department and legislative assembly, both of which shall be elective and representative of the constituent units. The powers of government, as contemplated in the provision on autonomous regions, should be vested on the entire government and not the parliament, as it is provided in the bill in question, Mr. Chairman. By the way, the bill does not state how many members the cabinet should have. I think the comprehensive agreement on the Bangsamoro provides for a 50-member cabinet, a majority of whom shall be appointed by the Prime Minister from among the members of Parliament. In any event, the members of Cabinet are not elective. The Constitution, however, requires that both the Legislative Department and the National Assembly shall be elected. Well, because the bill provides for a parliamentary government. Fourth, Mr. Chairman and members of the committee, still on the government of the Bangsamoro, the powers now. Under the bill, the Bangsamoro government is given extensive, exclusive, and concurrent powers over matters enumerated therein. There's a long list of powers that are given to the Bangsamoro government. Whereas the central government is limited to those enumerated therein and to those which it shares with the Bangsamoro government. The Philippine government is given reserved powers over the following, only 7 items, I believe. 9 items. Defense and external security, foreign policy, coinage, monetary, postal service, citizenship and naturalization, immigration, custom and tariff as qualified by Section 2, Paragraph 10, Article 5 of the bill, common market and global trade, and intellectual property. and concurrent powers over the following matters: social security and pensions, quarantine, land registration, pollution control, human rights and humanitarian protection and promotion, penology and penitentiary, auditing, civil service, Coast Guard, customs and tariff, administration of justice, funding for the maintenance of national roads, bridges, and irrigation systems, disaster risk reduction management, and public order and safety, which is in the Constitution. Thus, under the bill, the central government would be like the federal government of the United States, a government of enumerated powers with the balance of powers retained by the governments of the several states. The Philippine government, however, is a unitary government, and as such it has all the powers of sovereignty, except only those that are given to autonomous regions by the Constitution itself, namely administrative organization, creation of sources of revenues, ancestral domain and natural resources, personal, family, and property relation, regional, urban, and rural planning development, economic, social, and tourism development, educational policies, preservation and development of the cultural heritage, and such other matters as authorized by law for the promotion of the general welfare of the region, the usual general welfare clause that local governments enjoy. What I'm trying to say, Mr. Chairman and members of the committee, is that the central government under the bill in question has only limited powers, which is contrary to the Constitution, which vests in the central government, the national government, as the repository of all powers, minus only that are given by the Constitution or by law to the members, rather to the regional governments, the autonomous governments. I want to emphasize that we are not a federal system. And so what the central government possesses is the totality of powers minus only those that are given to the autonomous region. Whereas in a federal system, the central government or the federal government enjoys limited delegated power to it by the several states, in which power is really reposed. Fifth, the general supervision of Bangsamoro government. This is not in the comprehensive agreement, and I'm glad to see that somehow there is an effort to comply with the Constitution by inserting this provision in House Bill 4994. Still, I find it a little doubtful as to its conformity to the Constitution. Under the Constitution, the President has general supervision over the autonomous regions to ensure that the laws are faithfully executed. This cannot be diminished, modified, or qualified in any law because that is a constitutional provision. However, the bill provides that the President shall exercise his power, quote, consistent with the principle of autonomy and the asymmetric relation of the central government and the Bangsamoro government, unquote. This is the qualification that waters down the already limited power of general supervision that the President has over autonomous region. When you make it subject to the asymmetric relation announced in the, or underlying the relationship of the two governments in the bill in question, then you can see that the President's power of general supervision is almost illusory. This can make strict enforcement of national laws within the Bangsamoro territory difficult to secure, as law enforcement therein may have to take into account the local custom of the people, all in the name of the asymmetric relationship of the government. A final word on the asymmetric relationship of the central and Bangsamoro government. Indeed, the provisions of the bill, which are contrary to the Constitution, cannot be justified on the ground that the relation of the central government and the Bangsamoro government is asymmetric. That is to say, based on the bill itself, the relationship is, quote, distinct from the intergovernmental relation in other regions and other local governments. The question is precisely whether the bill is not contrary to the Constitution because of such asymmetric relationship between the two governments. Such relationship cannot justify the recognition of the right of the Bangsamoro people to self-determination, to chart their political future without impairing the sovereignty and the territorial integrity of the Philippines. Indeed, the creation of the autonomous regions in Muslim Mindanao and in the Cordilleras must be within the framework of the Constitution and the national sovereignty, as well as the territorial integrity of the Republic of the Philippines. And the laws of the regional governments must be subject to the provisions of the Constitution and national laws. This was emphasized by the court in its decision in validating the MOA-AD of 2008 after finding that Bangsamoro juridical entity created by it was a state in all but name. For these reasons, Mr. Chairman and members of the committee, and without prejudice to the submission of additional observations for lack of time, which I did not get to prepare them, I am of the opinion that HB number 4994 is beyond the powers of Congress to pass, appreciative as I am of the efforts done toward making the bill conform to the Constitution. Thank you, Mr. Chairman.